so then it's just...
Perfect. Thank you. Yeah, hey, thanks. I keep putting stuff on this piano, and I'm probably not supposed to. But. I bet you almost never use PowerPoint. I almost never do. I use it in 3 classes in American government, and I use it most of the time in Western Civ. But there it's just images. And that's it. All just images.
Oh, I see.
Yeah.
Yep.
So, battles or whatever. Well,
Good afternoon, everyone. Welcome, and thank you for coming this afternoon to hear about the Constitution and about the U.S. presidency. Today's event is an educational offering of the Lincoln Program and American Founding Principles here at Regent University. The Lincoln Program exists to promote understanding and appreciation of the ideas, people, and historical context of the American founding and of the American political tradition. In his famous Lyceum address, Abraham Lincoln argued that the greatest threat to the perpetuation of the American Republic came not from external threats, but from domestic disregard for the Constitution, the laws, and the principles of the American Republic. The Lincoln Program exists because this is still true, and it serves to provide educational opportunities such as seminars and public lectures such as this one today for Regent University students, for secondary teachers in history, civics, the government, and for the general public. Today's event is made possible by the Jack Miller Center for Teaching America's Founding Principles in History. The Jack Miller Center works with professors and educators to ensure every student has the opportunity to learn the history and principles at the heart of American political life. Today's lecture is titled The Seductive Lure of Prerogative Power. And our speaker is Dr. Caleb Verbois, Professor of Political Science at Grove City College in Grove City, Pennsylvania. Dr. Verbois' writings on the presidency and on political theory have appeared in Presidential Studies Quarterly, the Journal of Religion, Culture, and Democracy, and in a number of newspapers, magazines, and other periodicals. He also contributed a book chapter to a volume titled The Political Thought of the Civil War, published by the University Press of Kansas. He received the BA from Oglethorpe and the master's degree and PhD in political science from the University of Virginia. Please join me in welcoming Dr. Verbois.
Well, thank you very much, Dr. Redinger, and thank you for inviting me to come speak on the Constitution, and for all of you for coming to hear me. I'm glad to be back on this beautiful campus. I lived within a couple of miles of it and taught here actually for 3 years, about a decade ago, so it's nice to be back. I have three basic goals. I want to give a framework for why I think the Constitution still matters. Even, I want to suggest, in a political context where increasingly it seems that Americans know less and less about the Constitution, and where major figures on both sides of the partisan divide frequently dismiss the Constitution. Second, I want to talk about a specific area of constitutional debate over presidential power that I think is a good possible example of this. And then third, I want to give you a chance to ask questions. Right? So that's what we're looking to do today. So to give more detail on the first 2 points, right, our Constitution is coming up on its 250th anniversary. And not for the first time, there are many voices in our society that argue it's time to move on from it. I want to look briefly at some historical critiques of the Constitution and at some of the contemporary debate. And I want to suggest that while the Constitution isn't perfect, it's the best we've got, and we should still pay attention to it. Second, one of my main areas of interest is presidential power under the Constitution. It's what I wrote my dissertation on. I recently published a piece on this, and not because I don't hate all of you, I'm not going to read from an academic journal, because if Dante were alive now, he would put that in like his fifth circle of hell. But I do plan to hit some highlights that relate to this question of why we should still apply the Constitution. So, does the Constitution still matter, right? Why should we care? Right? Well, at least in part, because as the Constitution was designed both to empower, let's see, this should change. It was working earlier. Maybe not. If somebody wants to help with this. Otherwise, I can walk back and forth. Maybe. But the Constitution was designed both to empower government and to be the great protector of American liberties. There have always been critiques, right? Many times in past American history, people have asked, why should we be limited, some variation of this question, why should we be limited by a constitution written by a bunch of dead white men, right? Many of whom were slave owners, right? Famously, one of the great abolitionist leaders in the 19th century, William Lloyd Garrison, called the Constitution a covenant with death, right? But Frederick Douglass argued instead, yeah, perfect, there we go. Can I flip that? Yeah. Excellent, thank you. Frederick Douglass called it, William Lloyd Garrison called it a covenant with death and an agreement with hell. Frederick Douglass, on the other hand, argued that while the Declaration of Independence and the Constitution's principles hadn't been extended to slaves yet at the time that he was talking about, the promise was still there. And from Douglass's perspective, the problem wasn't the Constitution. The problem was the hypocrisy of simultaneously claiming all men were created equal with liberty and not applying it to all men. Ultimately, the Civil War, and Lincoln, I think, is the prime example of this, was a crisis about how to interpret and apply both the Declaration and the Constitution. And it only ended when it was finally acknowledged that the principle of freedom in both documents had to apply to every American, or we weren't living up to our own principles. But arguments against the Constitution are common today. Consider then Senator Joe Biden asking John Roberts, when Roberts was up for nomination for the Supreme Court, don't talk to me about what the Constitution means, I don't really care, tell me instead how you feel. Right? Or just last month, the dean of the Berkeley Law School published a book titled No Democracy Lasts Forever, right? With the subtitle, How the Constitution Threatens the United States. In it, he argues, among other things, that our reverence of the Constitution has kept us from focusing on its flaws. In particular, Dean Cherminsky argues that the problems with the Constitution come from the same source. What he means is that all of the various means that the Constitution has that allow a minority of the population to slow what he sees as progress and change. This, I think, is a really important point. A frequent critique of the Constitution today is that it isn't democratic enough. The people's will isn't put into effect efficiently enough. But from the founders' perspective, this isn't a bug. It's not an accident. It was a feature. In particular, Madison wanted the Constitution to limit majority rule. Why? Because in any society, in any group of people, the majority so often tyrannize the minority. Right? If you want sort of an example of this, for many of you, just think back to middle school. Right? This is basically what Madison is talking about. Right? Any large group of people are kind of like mean girls in middle school. But Cherminsky sounds, in some ways, oddly similar to Donald Trump, who argued after the 2022 election that since the 2020 election, he says, was stolen, the results should be thrown out, and that even the Constitution's own rules should be terminated. Right? It's curious, I think, how similar the objections to the Constitution can be from people on the left and the right that don't actually agree on much else. Frequently, their critiques of the Constitution amount to, well, the people agree with me, and the problem is that the Constitution won't let us act. And so what we need to do is ignore this part of the Constitution because I promise the people are with me. Right? I want to show you some results from some recent polling that I think is both telling and fairly disturbing, right? In terms of a couple of things. One, how little we know about what the Constitution says, and two, how little we care to apply it when convenient for sort of our political side, right? So for example, increasingly, Americans can't name the First Amendment protections. I do this actually every semester in my American government class. I ask the class just as a group to quickly tell me the 5 rights in the First Amendment. And typically, everybody can get the first 2 or 3, and whether the class as a whole gets all 5 depends on if one student knows all 5, because no one remembers what the right to petition is about. But practically speaking, right, while we often say that we like the Bill of Rights, we have the same approach to it that we do to, say, the 10 Commandments. We say it's things that we should all follow, but we only can name like 3 or 4 of them if you survey Americans on this. Right? But also, we find increasingly that Americans want to change aspects of the Constitution, in particular aspects of the Constitution that would make it more democratic, right? And increasing support for changing the Electoral College is just one example of this. More troubling, I think, is that an increasing percentage of Americans on both sides of the partisan divide both want secession and B, are deeply skeptical of democracy. Now, the next 3 slides are all results from the UVA Center for Politics. It's a nonpartisan center that polls Americans on questions like this relatively frequently. The red is Republican voters, and the blue is Democratic voters. These polls, these next 3 questions are all taken from last fall. But the results wouldn't have changed that much year to year. And what you see in them is one, that a striking number of Americans think democracy is bad, and secession is good, and 2, Republicans are much more in favor of both of those than Democrats are. Right? But if we break it down further, look particularly here at the 1st and 5th columns, Democratic voters in particular are increasingly interested in the government restricting a variety of rights in the name of the Democratic majority. But Republican voters, on the other hand, increasingly want national laws. Look here at the 1st, 4th, and 5th results. They want national laws to force patriotism of whatever kind they decide is favorable at that particular moment in time. And a shocking number of both Republican and Democrats believe elections should be suspended during times of crisis. Now, I want you to think about how big of a deal this is. We didn't cancel or postpone elections during the middle of the Civil War. People actually talked to Lincoln about it in 1864. They said, maybe you should suspend elections. And he said, are you crazy? On what basis would I continue to be president if I could do that, right? Like, that's not an option. It's not a thing I was aware someone could do, right? He says we have to hold the elections and we have to deal with the results. We didn't suspend elections in World War I. We didn't suspend elections in World War II or in Vietnam or at any point in the Cold War, right? And now we have a large number of Americans, not a majority, but an increasing plurality that says maybe we should suspend elections in a time of crisis. Sort of begs the question, who decides what counts as a time of crisis, right? And how do we know that they'll do that very well, right? Increasingly, Democrats critique the Constitution by calling it a tyranny of the minority. Their critiques of the Electoral College, of gerrymandering, and of a conservative Supreme Court all neatly fit into this category, and their solutions, a popular vote for the presidency, computer-generated districts for the House of Representatives, and additional judges and term limits are all part of an attempt to make the Constitution operate in a more directly democratic way. But Trump and his allies who've criticized the Constitution actually make surprisingly similar arguments. Trump has explicitly called for the constitutional rules to be voided to overturn what he falsely calls a stolen election. He regularly complained as president that there were too many limits on presidential power. And increasingly, in the last few years, Christian nationalists and Catholic integralists have argued that liberal democracy, and with it the Constitution, is problematic. And what we really need is strongman leadership. Now, it's curious, none of those groups ever talk about strong woman leadership. That doesn't seem to be a thing that occurs to them as a possibility, which is a different story entirely. But what I want to suggest is that we've heard these kinds of claims before, right? To turn democracy into strongman leadership, but rarely in American politics, right? Where have we heard them, right? Well, at Grove City, I talk about them every semester in Western Civ when we get to mid-20th century Europe, right? And that's a pretty dark comparison, right, if you think about it for not very long. In short, what I want to suggest is that the contemporary critics of the Constitution don't fall into neat left and right divides, right? Both actually dismiss the support for the Constitution as a type of nostalgia. What they have instead is that they are all appeals to brute power. Right? The people are behind me, and therefore I should be able to do whatever I want for them without limits, because the people are in charge. I want to suggest that this is inherently dangerous. Right? Now, I'm not saying the Constitution is always right. It isn't. I would argue, in fact, that it needs some reforms. But the great genius in the Constitution is its recognition that a nation of the people, by the people, for the people, also must be able to restrain the people, because the people aren't always trustworthy. Right? In particular, Madison's great concern was of majority tyranny over a minority, because, as the founders repeatedly said, every large assembly of people is to some degree a mob. Right? Individually, we can be very thoughtful, kind, and smart. Put us all together arguing about a controversial topic, and we descend to the level of mean girls in middle school. Right? And actually, there's an increasing amount of research that suggests this is true even on particular issues. So you take 20 people that all agree in general on a controversial issue. Take your pick of issues: gun rights, LGBT issues, Christian nationalism, taxes, anything. Give them an hour to talk about it, and at the end of the hour, all of them are more extreme than the most extreme of them started at the beginning of the hour. Right? It's a very odd phenomenon that sort of relates to the fact that we all want to be liked all the time. Right? I mean, a few of us maybe not, but most people do. Right? When you add that in to the way in which politically we increasingly interact online rather than in person, we get more extreme very, very fast. Right? And completely farcical or false claims made by our preferred political candidate become axiomatic beliefs and truths very, very fast, even though we should know better than to believe them. And we can all think about examples of this from the last week, right? Much less the last 6 months. But this idea that large groups of people can turn into a mob isn't just a belief the founders shared, it's also a belief informed by the doctrine of original sin. Right? We don't actually always do or want what we ought to do or want, and we often do what we know we ought not do. So whether it's coming from the left or the right, I'm personally deeply suspicious of arguments that because the people want something, what they want must be good. Now, I could say more about why the Constitution should still matter, but I want to turn now to this particular area of constitutional focus and disagreement of presidential power. Right? Now, so as a little background, I first got interested in this, which ended up being sort of the focus of my dissertation in a graduate class on the presidency. I was a student at the University of Virginia, and during that semester, we were reading the Helvidius Pacificus letters. Now, some of you will be familiar with these, many of you won't be. They're a series of anonymous letters written by Madison and Hamilton during Washington's first term. Now, Madison and Hamilton, of course, also write a bunch of anonymous letters under the pseudonym Publius when the Constitution is being debated, right? So they are the principal authors of the Federalist Papers. When they're writing those, John Jay writes 6 letters, Madison writes about 28, and Hamilton, because he's kind of a beast, writes 55 one summer while also working full-time as a lawyer, because he's one of the only founders who's not independently wealthy. But they, when they're writing the Federalist Papers, are kind of all on the same side together. Publius becomes schizophrenic not that long after Washington's presidency. Madison and Hamilton have what becomes a kind of irrevocable political break. Madison identifies more with Jefferson's understanding of the Constitution, which turns out to be a little strange because Jefferson wasn't there when it was all happening. And Hamilton has a much broader reading of it. But in Washington's presidency, they're arguing about a particular action of Washington's that doesn't really matter for our purposes, but Hamilton is arguing for a broad reading of presidential power, and Madison is arguing for a very narrow one. And so I'm reading these as part of a class, and that same semester, during the War on Terror, there was news leaking about George W. Bush's warrantless wiretapping program that he used to the National Security Agency. And there were hundreds of op-eds and articles and academic pieces that all came out at the same time. And I was reading a bunch of them, and I was struck by the fact that a number of lawyers and academics were arguing that Bush was doing something fundamentally new, an abuse of constitutional power. But the arguments that I was reading that were made for and against Bush's decisions sounded to me almost identical to the arguments that I was reading from Hamilton and Madison. And I said, that's really interesting, right? How can this be sort of fundamentally new if it's this really kind of old constitutional argument? And if the founding fathers had an argument about something at the birth of the Republic, did it really make sense to say that Bush was doing something fundamentally new? And that really is what I'm interested in American politics, right? What was the purpose and intent of something in the Constitution, and how has it changed over time? So I want to start in thinking about this with Lincoln. In considering the Constitution and the presidency, I think he's basically always the right place to start. Lincoln was concerned, right, about the legitimate use or abuse of executive and national power. And he asked at the outset of the Civil War, is there in all republics this inherent and fatal weakness? Must a government of necessity be too strong for the liberties of its people, or too weak to maintain its own existence? He ultimately says, no, right? Actually, there has to be sort of a middle ground. But what I want to suggest here at the start is that debates about the extent, legality, and extra-constitutionality of presidential power have existed from since the ratification of the Constitution, but they're always sort of extenuated or attenuated during times of national crisis, right? Or during really long-standing, extensive foreign engagement. We're living in one of these right now. We don't think about the war on terror very much because we're Americans and we mostly think about like the next Memorial Day sale, but it's still actually actively going on, right? And so in this paper that I mentioned, I go through an extensive literature review on the scholarship, but I want to just summarize this for you because I don't want to subject you to a literature review here. But what I want to suggest is that there are sort of 4 basic views on presidential power. And I'll mention each of these and then I'll talk about them in some more detail, right? And so the first of these says, well, the Constitution limits the president fairly sharply, and he has no power, prerogative or otherwise, and I'll talk about what prerogative means in just a minute, to act beyond its confines, right? There's this sort of very strict literalist reading of the Constitution. The second view agrees with that literalist reading of the Constitution, but says, well, there's this thing called prerogative, right, that allows the Constitution to violate the Constitution when necessary. The third view, right, says, well, actually, prerogative doesn't violate the Constitution, and it's really necessary. And the fourth view says, well, actually, all 3 of the first are wrong. right? Prerogative doesn't make any sense, and it's inherently dangerous. But nothing in the Constitution says that we have to read it really literally, right? We just have to read it reasonably, like we read any other law. So let me break these down a little bit. The first view is held by people who tend to read the Constitution very strictly, very literally. The best presidential example of this is probably James Madison, who read the Constitution as so limiting the president that he became sort of fundamentally ineffective during the War of 1812, so much so that he almost got the White House burned down from under him. It was burned down, and the only reason he wasn't there is really because his wife packed up the national treasures in the White House before he got back so they could flee. The second and third views are variations on an idea called prerogative power. So what does this mean, right? John Locke is a British Enlightenment theorist who coins this idea of prerogative power. And his starting point, his starting assumption, is that there will always be unforeseen circumstances and surprises that the law cannot account for. So sometimes the executive, and he's not thinking in presidential terms because he's thinking in terms of the English monarchy, but sometimes the executive must act in the absence of law or even in violation of law. Now, this is an extraordinary kind of power. Locke is explicit about it, right? When the president or when the executive is acting on prerogative, the only judge of whether or not he's doing so rightly is the executive himself. And the people's only remedy, if they think the executive is in the wrong, is what Locke calls an appeal to heaven, which is a phrase that he uses when he means a violent revolution, right? And so this power means that the only way to stop it is a violent revolution, which is not something that's going to happen every day, so it's essentially an unlimited power. For Locke, in other words, there's this sort of reservoir of power somewhere out in the ether that executives can appeal to at their discretion in an emergency. And importantly, who determines what an emergency is? The same executive that's going to use this reservoir of power. It's a neat power if you can sort of have it. The question is it a trustworthy power, right? Because for Locke, again, there's no meaningful check short of an armed revolution. Both these second and third views that I have up on this slide think Locke is right. They just disagree on whether or not this power is sort of baked into the Constitution or not, whether the founders intended it or whether they intended it or not, it just sort of has to be there. So this second view is also held by people who interpret the Constitution pretty strictly as having sharp limits on the president. But they believe there's this special out in certain circumstances where the president can illegally, maybe unconstitutionally, but justifiably act on prerogative power. The primary example of this is probably Thomas Jefferson, and I'm going to talk in a little bit about a Jeffersonian example of this. This third view is actually a more modern view. It's held by a number of conservative legal and political scholars who argue that prerogative is actually constitutionalized within the presidency. And this view comes really close to saying if the president does it, that means it's legal. And the primary presidential examples of this are probably Richard Nixon and Donald Trump. The fourth view, and full disclosure, it's the one that I hold, is distinct from the other three. It rejects prerogative as something that isn't found anywhere in the Constitution. It isn't found in the text. It isn't found in any of the constitutional debates. It isn't found in any of the ratification debates. It wasn't something that they were talking about at all. But it also rejects the argument that the Constitution has to be read very strictly, right? Why? Right? Well, because the Constitution doesn't say it has to be read very strictly, right? The Constitution is just a legal document, and it should be read reasonably according to the same sort of processes we might read any other legal document. So this view suggests that prerogative is unconstitutional, but the president's powers under the Constitution should be interpreted quite rather broadly. Presidential examples would include George Washington, Abraham Lincoln, and more recently at times, George W. Bush. Now, what I want to suggest is that the fourth view is the only view that makes sense with the nature and development of the Constitution, and the only one that can avoid this problem of majority tyranny, right? Because it's really the only one that actually limits the presidency in the long run. But first, why is the idea of prerogative, of granting the president the power to violate the law or the Constitution in an emergency, so appealing to so many people? right? At its core, the idea of prerogative as applied to our constitutional system in America suggests that while the Constitution creates or establishes like a narrow range of legitimate presidential powers, the executive can act beyond them in an emergency, right? They insist, proponents of this idea insist the power is necessary because there will always be crises that require executive action. And it's too dangerous to read the law broadly enough to account for all necessary executive acts. Because the Constitution is inflexible, when situations come up that are outside of its specific grants of power, the government must give sort of a pretense of legal sheen to actions that are really illegal. Right? So, in the context of the War on Terror, for example, prerogative allows for Congress to ban torture and for presidents to authorize it illegally if there's like a ticking time bomb somewhere. Right? And that's appealing to a certain type of person. For these prerogative supporters, it allows the president to violate the law or even the Constitution for the greater good without claiming the Constitution itself does so. So what then are the essential presuppositions of this idea? Right? Number one, that the Constitution is limited and it's an inflexible document that doesn't allow for necessary actions. Number two, there are some things like torture, for example, that we should never make legal, but sometimes somebody has to do it. And three, it's safer to give the president the power to violate the Constitution than it is to interpret the Constitution broadly. Right? I don't know that I think any of those three are true, but those are the assumptions of this idea. But it's not clear that either of these approaches, an extra constitutional prerogative or sort of a constitutionalized one, solve the problem. Why? Because merely making the president an elected official doesn't make it safe to give him the power to violate the law. Because it's not clear that that power could ever be truly safe. Importantly, there's no constitutional text, there's no debates from the Constitution, there's no Supreme Court opinions that justify prerogative. So why do prerogative proponents argue this? Because they're worried about reading the Constitution and stretching its meaning too far. So they say, what we want to do is we want to read it narrowly so that we don't overstretch it and turn it into something else. Because if the Constitution is read too broadly, it will create a series of kind of cascading precedents that will ratchet up the power of future presidents. Right? On the other hand, reading the Constitution narrowly, but sometimes violating it, won't create precedent for future presidential leaders to do the same thing. At least that's the theory. The question is, why would that hold up? Right? And what I mean by this is if the only way to judge prerogative is whether it was for the good of the public, how do we know what the good of the public is? Right? What's the standard for determining what the good of the public is? And who gets to make the determination? Right? Under prerogative theory, it's the same guy that gets to violate the law. Again, that's a convenient power if you can pull it off, but it's not really clear why it's safe for the rest of us. Right? This makes the executive unlimited, bound to nothing but his own conscience and sense of duty. Experience taught the founders, not to mention us as contemporary Americans, the danger of trusting the conscience of political leaders. Sometimes it turns out some of them don't have a conscience, right? Or at least not one that's very trustworthy, right? And sometimes it doesn't really work to trust like the good judgment of American citizens. Because again, in large groups, people tend to be the mob, right? And we aren't always that trustworthy. This was exactly what the founders were anxious to avoid. So it makes little sense to assume they intended to incorporate it in the new Constitution. Now, the founders did want a pretty strong executive. They're pretty clear about this, and you read through the Constitutional Convention. Right? They wanted an executive who could act with secrecy, with energy, and dispatch. Why? Because there are unexpected problems and emergencies, and that's the kind of thing that a president needs to deal with. But they didn't think that this required extra constitutional or extra legal power. Rather, they thought that both the government and the executive needed to be vested, right, with sufficient authority to act where necessary. Right? Laws can be complicated, and it can be difficult sometimes to determine if an executive has broken a law. But crucially, there's like an actual mechanism for determining that. We can read the law and evaluate it. There's, at least in theory, legitimate options if an executive breaks the law. We often don't enforce them, but we could, right? It's a legal option under the Constitution to do so. There's no legitimate constitutional recourse to an executive's misuse of prerogative power. But this is all really fairly theoretical and possibly a little too vague, right? So let's think about this in like a practical example, right? Let's consider Thomas Jefferson, right? So Thomas Jefferson, and specifically the Louisiana Purchase, right? So Jefferson spent most of the first dozen years of the Republic's history arguing against Hamilton's broad reading of the Constitution. He campaigned in the election of 1800 on a literal textualist reading of the Constitution, and he thought that the government and the presidency had a very limited amount of powers. But then he became president, and his thinking started to shift a little bit, right? And I can say this because I went to the University of Virginia, and that's sort of Jefferson's baby. But Jefferson's a brilliant thinker, but there's almost nothing that he ever said or wrote that he didn't say something more or less the opposite of somewhere else. So when you ask, what did Jefferson think about X or Y, like, the answer always has to be something like, well, which Jefferson are we talking about today, right? And so Jefferson was very much opposed to presidential power when he wasn't president, and he had a rethinking of this once he became president, right? Jefferson was also an agrarian who was constantly concerned with getting farming produce out to trade. I mean, he didn't personally do the labor for farming, but like, he was concerned about how to make money off of it, right? And so as president, he was heavily invested in getting American control of the Mississippi River, and especially the port of New Orleans, because in the time period that we're talking about, the most effective way to get produce out, to move goods of any kind, is through water, on water transportation. So when he becomes president, he sends diplomats to Napoleon, right, who currently has control of New Orleans, and he says, I would like to buy New Orleans from you. Napoleon is surprisingly amenable to this, because Napoleon is currently trying to fight literally all of the great powers of Europe, and he's broke. And so he says to Jefferson's negotiators, I'll sell you not just New Orleans, but all of the Louisiana Purchase for $15 million, right? Jefferson thinks this is great. It's essentially the opportunity to buy Bitcoin when it first comes out. I mean, no one really knows what's in the Louisiana Purchase. Like, we look at maps now from 1803 and like, look, this is like, it doubles the size of the American country at the time. But at the time, they didn't actually know that because no one knew how far it went, right? It's very vague where it goes. But there is at least this sense that it's a pretty good real estate deal, right? So Jefferson is excited about it. But Jefferson has a real problem, right? You see, he has a constitutional problem because he's a literalist in his reading of the Constitution. And nothing in the Constitution explicitly says anything about adding more territory by treaty. As Jefferson admitted, the purchase ran directly counter to the doctrine of strict construction, because the authority to buy territory from foreign governments is nowhere specifically listed among the enumerated powers in the Constitution. And so Jefferson doesn't think it's constitutional. Now, Hamilton, on the other hand, has no problem with this, right? He thinks, of course, the U.S. can buy Louisiana Purchase. Why? Because the United States is a government. And all governments, in the history of governments, can add territory in one of three ways: by exploration, by conquest, or by treaty. We can make a treaty, and we can pay for it, and there's no real problem with that. That's part of what it means to be sovereign. But Jefferson can't make this argument theoretically. But it's such a good investment deal, he can't turn it down. And so he starts to write to some of his allies and says, well, what we need is a constitutional amendment. And they start to have some serious thinking about this. But then his diplomats in Paris write to Jefferson and say, okay, here's the problem. This is a limited time offer. If you don't say yes to this quickly, Napoleon is either going to change his mind or sell it to someone else. And so Jefferson, again, it's a good deal, writes to his allies in Congress and says, you remember that constitutional problem, that amendment that I wanted you to do? Don't say anything else about that. Let's pass this treaty. He says, sub silentio. What he means by this is, let's not mention our constitutional concerns. Let's just say it's going to be okay, right? And we'll deal with it later. And the Jeffersonian Republicans in Congress say, great. Now, curiously, and we can talk about this if you want, the Federalists, who should constitutionally have no problem with this, actually bring up lots of constitutional concerns with it in Congress, and they sound a lot like the Jeffersonians had about 3 years earlier, right? So partisanship warps constitutional debates even in the founding generation, right? But how does Jefferson justify this in his own mind? On prerogative grounds. He just doesn't ever say so publicly. Years later, he writes to a friend of his, and he says this: "The question you propose, whether circumstances do not sometimes occur which make it a duty in officers of high trust to assume authorities beyond the law, is easy of solution in principle, but sometimes embarrassing in practice. A strict observance of the written laws is doubtless one of the highest duties of a citizen, but it is not the highest. The laws of necessity, of self-preservation, of saving our country when in danger are of a higher obligation. To lose our country by a scrupulous adherence to written law would be to lose the law itself, with life, liberty, property, and all those who are enjoying them with us, thus absurdly sacrificing the ends to the means." Now, this is fascinating for a number of reasons. One, you can see how Jefferson has a sort of a way with words that almost no other political figure does. But two, hopefully you see that he uses that way with words to obscure what actually happened, right? Because he says, look, we've got to read the law very strictly, but we have to act to preserve necessity. But that's not what actually happens in Louisiana Purchase. I mean, it's a big deal. I'm from southern Louisiana. This is where I grew up. I'm glad it's part of America. But it wasn't a national security crisis. It was a really good opportunity to buy Bitcoin. That's all that it really was. It was a great real estate deal. And he wasn't even aware of how good of a deal it was. That's why he has to send Meriwether and Lewis out on their exploration. He's like, what did we just buy, guys? Go find out and tell us, right? But in Jefferson's own mind, it becomes a sort of story of national self-preservation. And this, I want to suggest, is part of the problem of prerogative. Because if you give a very powerful person the power to say, I can violate the law in necessity, it kind of turns out that everything is a necessity to them, right? That's how human nature works. Right? So to sort of conclude and wrap this up, extra constitutional prerogative power has been held out as a solution for the problems of presidents accruing more and more power through legal arguments, starting with the advent of the Cold War and accelerating since the beginning of the War on Terror. Theorists suggest there's so much reliance by presidents on sort of narrow legal readings from the President's Office of Legal Counsel, which is largely true, that presidents have become untethered from Congress. Instead, we should cease trying to justify presidential actions legally, and presidents should just admit they violated the law of the Constitution and rely on the public to sort of say yes or no, that's okay. But what evidence is there that any president has ever done that? One would be hard-pressed to look through the historical record to ever find a president admitting to violating the law of the Constitution. Even Jefferson didn't do so publicly. He just wrote to friends about it, and they published his letters anonymously later. Right? And even if a president were to do so, why would that be better? Right? Consider some of our most recent controversial presidents. Right? So for all of the criticism of George W. Bush and Barack Obama, and many of you in this room will not remember this because you were in elementary school at the time, both were ultimately restrained by either the Supreme Court or at times by Congress. Bush, for example, stopped waterboarding. He stopped military tribunals. Obama lost more unanimous Supreme Court decisions than any other president in history. But he never ignored the court. He never said, you guys told me I couldn't do this, I'm going to do it anyway. Right? However, if either of them had relied on prerogative power and argued that their acts were necessary for the War on Terror, or to solve the Great Recession, or any other sudden crisis, how could they have been meaningfully restrained? Locke says the executive alone justifies the prerogative act. Jefferson says the president should throw himself on the public, but who judges the public approval? The president. Right? Contrast that with Donald Trump, who has repeatedly said he doesn't feel compelled to follow the law or the Constitution, or even election results, if he wins a second time. Right? He's actually, I think, the best modern example of a president acting on prerogative power, or a presidential candidate saying that he would do so. And he pretty clearly has suggested that he doesn't find himself limited by the law, the Constitution, or the public. Why would that be safer? Right? there's a real reason, I think, to worry the presidency has become untethered from meaningful checks, right? Prerogative theorists, I would suggest, though, are wrong to suggest that the utilization of prerogative can solve this problem. To show the American system includes it, you have to show that there's evidence for it somewhere, right? You have to show the founders intended it, or that it's likely to lead to better results, or that it will be safer by preserving more respect for the law. None of these, though, can be compellingly demonstrated. I think the better path is to recognize that under the Constitution, the law can be followed and necessity provided for without either violating the Constitution or stretching it beyond its intended meaning. Now, you don't have to read John Locke or my paper or care all that much about presidential power to recognize that arguing constitutional limits shouldn't apply to someone merely because they're a popular leader, or they say it's an emergency, or they say the other side is wrong, might be really risky. I think the question of prerogative power is just one example of why the Constitution should still matter in a political context where we increasingly see that major political figures argue the Constitution doesn't apply to them, or that we should only be concerned with what the majority wants. That, I think, is a really dangerous place to be in, because who determines what the majority wants? In practice, it's often political leaders acting as demagogues with no meaningful check. That's a very dangerous place for democracy to go. Ask yourself this as you leave this afternoon. When you think about the latest crazy claim made by a current political figure, or the latest controversy, or the latest argument, is your first instinct to ask, is the claim true? Or is your first instinct to defend your side? Or to explain it away by arguing that the other side is worse? Because if your instinct is more to the latter, I want to suggest that that's a really dangerous way to think. Right? And it's perhaps an indication that you're willing to put your primary identity in partisanship rather than in the kinds of places that you should be putting it in, right? Which is another way of saying that the Constitution doesn't just matter on a really big picture scale. The way that we think about some of these questions ought to matter to us as individuals, right? With that, I will turn it over to any questions that you have.
Thank you, Dr. Verbois. We do have time for several questions, I think, depending on Dr. Verbois' answers. But go ahead and raise your hand if you're interested, and I will act as moderator. And Dr. Verbois, if you could just restate the question just to make sure that the mic picks it up for future recordings. Comments, questions?
Yeah. You mentioned that the research shows that people who critique the Constitution doesn't fall under necessarily right or left.
Yep.
I was wondering if in your research you found any correlation between the people who thought those things, atheist or Christian or male or female.
Okay, so the question here is if there's not much of a correlation between right and left in disagreement with the Constitution, is it in other sorts of things, so Christianity or atheism or gender? Yeah, it's a good question. Off the top of my head, I don't have an answer for you, just because I haven't been looking at that specifically. So there probably is one, but I'm not sure that I have an answer, right? I will say, in general, historically, and there is at least some evidence, that men are more likely to favor strong leaders, right? Or political leaders who seem strong, right, than women are, right? But that's not quite the same, it's not quite the answer to your question.
Thank you very much for your talk, first of all. My question is, if you could maybe explain what some of the practical differences are between the third and fourth view of prerogative power that you mentioned, between the idea that it's legal and baked into the cake, and the idea that, well, the Constitution should just be read broadly.
Yeah, sure. So the question here is, break down a little bit more the difference in these third and fourth views, right? Yeah. So it's something like this. The third view is making a philosophical and a constitutional argument that this idea of prerogative is actually intended in the constitutional system. Right? That's what it's arguing, right? And I'm suggesting it's hard to make that case given that they don't talk about it at all. right? You can go through the Constitutional Convention notes, and they use the word prerogative about a dozen times. But in every case, they're either talking about a state's power, or they're talking about how the king has prerogative power, and they don't want the executive to have that prerogative power, right? So it doesn't quite make the argument that they would like, right? The fourth view is arguing just instead that there is no power, there is no executive power to violate the Constitution, right? There is no executive power to violate the law. But nothing in the Constitution requires the Constitution to be read strictly. It's required to be read reasonably, right? So I'll give you an example, a practical example of how this works out. So since this is the Lincoln program, let's think about Abraham Lincoln, right? So Lincoln becomes president in 1861, and by the time that he's inaugurated, 7 states have already seceded, right? And so it's important to recognize, like, they don't secede because of anything that Lincoln does. They've seceded before he gets there. And when Lincoln gets to Washington, he has essentially an existential crisis. Washington is on the border of Virginia, which is about to secede, and its other border is Maryland, which is a slave state, which also may secede. And the problem that Lincoln faces is that he's in Washington, and he needs Congress, and Congress can't get there. Right? And so he starts trying to figure out what to do. And so one of the first things that he does is he calls up the militia. And he's criticized then and now for this because, well, under the Constitution, Congress has the power to call up the militia. And so the question is, well, has he violated the militia? And the answer is no in this case, because starting in 1791 and then amended about a half dozen times afterwards, Congress had passed a series of laws saying that in an emergency or a rebellion or an invasion, when Congress isn't around, the president can call up the militia. And it's specified under what circumstances and for how long and what he had to do to tell Congress. So he's acting under the purview of law, right? But then the militia starts trying to get to D.C. And the problem is that the primary way for them to do so is by rail, and by a railway that goes through Baltimore. And Baltimore, for reasons that only people from Baltimore maybe could explain, had 2 railroads that connected in Baltimore, but they didn't actually connect, right? The one coming from the north ended, and then you had to walk about 2 miles, and you got on a different railroad that went to D.C., right? I have no explanation any more than I can explain Baltimore's airport that I flew through this morning. But there's a militia coming through, and they're making this march, and they're assaulted by a group of secessionists in the streets, and it turns into this sort of bloody nightmare, right? Some of the soldiers are scared, and they shoot back, and civilians are killed, soldiers are killed, and so the governor of Maryland says, no more federal troops can go through Maryland. And Lincoln looks at that and says, yeah, no, we're not going to do that, because you're the governor and I'm the president, and that's not how that works. But then he does something else. He suspends the writ of habeas corpus in Maryland, right? Now, the writ of habeas corpus, some of you will know, many of you will not, is an Old English right, and the Latin roughly translates to show me the body. And what it basically means is the king can't just decide to, like, put the princes in the Tower of London and leave them there forever without a charge. He's actually got to show them before a judge and present a charge or release them. Right? It's seen as a fundamental right in the English common law tradition, and it's so fundamental to the founders that they put it in Article 1 of the Constitution. And what Article 1 says is the writ of habeas, this particular protection says the writ of habeas corpus shall not be suspended except in cases of invasion or rebellion. Right? So when Lincoln does this, he's immediately criticized, and he's criticized for a couple of reasons. One is you can't suspend the writ, and he says, well, that's not true. Right? You can suspend it in cases of rebellion or invasion. Guess what? We have the first right now. Right? The second criticism, though, is that the rules about the suspension of the writ of habeas corpus are in Article 1. Congress's powers are in the executive's powers are in Article 2. Congress's are in Article 1. But Lincoln says the thing is, they're in Article 1, but it's not in the section of Article 1 that gives Congress its powers. It's in the section of Article 1 that limits what the entire nation can do. And so he says the Constitution itself does not explicitly say who has this power. Right? So he says we can't assume that the president can't act on this power in a circumstance where Congress isn't able to act on this power because they can't get to the Capitol. Right? This is an example of a broad reading of the Constitution. You could argue against it. You could say Lincoln's wrong. But there's like an actual mechanism by which you can do that. Right? Instead of just saying, well, he said it was an emergency, I guess we have to trust him. Right? It's a long answer to a simple question, but hopefully that helps.
Thank you.
Yeah.
Other questions?
process to rectify said fraud.
Yeah. So the question is, hypothetically, if Trump was right in 2020 about election fraud, what's the proper constitutional means? I mean, look, the proper constitutional means is to go to the courts, right? And here's what we know about this, right? Trump did go to the courts, and he lost over 60 times, right? And afterwards, he said, well, I never lost because they never let my side present the facts. The thing is, that's not actually what happened, right? What actually happened is in court case after court case, his lawyers were asked to present actual evidence of fraud, and they sat down and didn't say anything, right? Because they didn't have any evidence that would stand up in front of a court of law, right? But that would be the mechanism that you could use, right? The difficulty with it is you have to actually have evidence, right? Now, I'm not saying that no one committed fraud in the 2020 election, right? Somebody probably commits fraud in every election, right? Somebody commits fraud in a school board election, dog catcher, whatever, right? Why? Because we're a nation of 330 million people, all of whom are sinners, right? But the argument is that there was some fundamental high level of fraud that was part of almost a kind of a criminal conspiracy, and there just isn't any evidence for it.
So when you mentioned prerogative power being unconstitutional, but the broad interpretation, what are some limits on how broadly we can interpret the Constitution?
Yeah, so the question is basically, hey, you're saying we should broadly interpret the Constitution. How do we limit that, right? Yeah, so look, I'm speaking at Regent University to, I assume, a fairly conservative audience, right? When I say broad interpretation, that shouldn't send shivers down your spine, right? It does in a certain context in political conservatism, say post-Reagan, right? But do you know, one of the first major figures to say that we should read the Constitution not strictly, right, not narrowly, but reasonably or broadly, is Chief Justice John Marshall, right, who was the second Chief Justice of the Supreme Court and really seen as kind of the first great originalist justice. And the reason he says this is because the Constitution doesn't, he says actually in Gibbons versus Ogden, an 1819 Supreme Court case, he says, I'm often told that I need to read the Constitution narrowly. Why? What does that mean? Nothing in the Constitution says that I should do that. He says, I think what people mean by that is that I need to read the Constitution in a way that makes it difficult for the national government to do the things the national government needs to do to be effective. But the Constitution doesn't tell me that at all. So what I should do is read the Constitution reasonably as I would read any other legal document. In other words, what Marshall is saying is that lawyers and judges are trained on how to read legal text, right? And the goal of reading a legal text is to understand what it means and apply it to particular circumstances. And to do that, you just have to read it reasonably, right? That's always a debatable point, right? But again, what I'm suggesting is that at least there's a point to debate, right? There's a metric by which we could judge it. Right? Another way to put this is Scalia famously said in talking about originalism, he said, the benefit of originalism is that it provides a standard by which you can tell me that I'm wrong, right? A lot of other judicial interpretations don't provide that standard, and prerogative power has the same kind of problem.
One, maybe two more questions. Gentleman in the back.
So, how would you interpret Franklin Delano Roosevelt's acts when in the presidency, when he, did a lot of things that we would consider unconstitutional, and then said that, I will, obey the Constitution according to how I interpret it. How would you?
Yeah. Franklin Roosevelt, so you're asking about? Yeah, okay, so the question is, how do you apply this to, say, FDR, right? Who has his own, we'll say, interesting interpretation of the Constitution. Yeah, so I will try to provide a short answer to what is a really big question, right? And the short answer is something like this. FDR was a really brilliant politician, right? And I mean that in all of the meaning that that can entail. Right? So he looks back at Teddy Roosevelt and Woodrow Wilson, who were not brilliant politicians in many ways, and he says, I think I found out what they did wrong. What Wilson said, for example, is Wilson famously really didn't like the Constitution. And he was pretty explicit about this in a number of different writings. And he especially didn't like the Bill of Rights, because the Bill of Rights, as he saw it, was a great deal of kind of mumbo jumbo, and it limited what the government could do, because what Wilson wanted was a kind of populist demagogue leadership. Right? FDR looks at that and says, well, the smarter way to do this politically is to not say rights are bad, but to reinterpret rights. And I think he does that to a pretty great extent. So you can think about this, for example, with his economic Bill of Rights. Right? It's a famous speech that he gives during the Great Depression, where he comes out and says that Americans need these, and he lists 8 economic Bill of Rights. And he says that once we have these, we'll have security. And once we bring them worldwide, he actually says, then we'll have essentially world peace. And he presents these as essentially the equivalent of a modern Bill of Rights. But of course, the original Bill of Rights is presented by Madison, it's debated by Congress, it's ratified by Congress and the states, and FDR's economic Bill of Rights is given by him in a speech. Right? But in practice, we've put into effect everything that's in that Bill of Rights, right, over time. Right? I think that the rest of the answer to that question is FDR, under the New Deal, represents a kind of a series of unwritten constitutional amendments, right? The reason that they hold up is because, well, the Great Depression is so terrifying to the American public that for an extended period of time, we're willing to sort of say as a country, we like the Constitution, and we're not going to be too fussed about whether or not we're following it. And once that's put into place, it's really hard to change it. Right? One more, maybe?
Last question.
So you said early on how, in your opinion, the Constitution needs to be revised. What revisions would you suggest for the Constitution?
Okay, so the question is, I said there could be revisions for the Constitution now. What sort of revisions, maybe? Yeah. So partly what I mean there is that I think it's okay to say the Constitution is good but not perfect, right? I don't have like 3 things that I think would fundamentally solve all of our problems if we change that in the Constitution. What I would say is that some of the, I'll give you a brief example, or hopefully a brief example. Some of the things that Madison and Hamilton thought would work in the Constitution don't work anymore. Not because the Constitution has changed or because evil conservatives or evil liberals did something wrong, but because technology change has rendered some of their precautions more or less irrelevant. And so what I'm thinking here actually is specifically about what Madison and Hamilton say in Federalist 9 and 10 and 51. Right? And some of you will be familiar with this, some of you won't be, but what they're talking about, those 3 Federalist Papers are, for my money, like the greatest understanding of the problems and some of the solutions to those problems in Republican government. And what they're talking about is the problem of factions, right? About a small group of people or a large group of people wanting their own benefit over everybody else's, and the problems and the needs, the solutions of an extended republic. Right? And the basic idea is something like this. In a larger extended republic, it will be harder for one faction to gain sort of majority control everywhere because people's interest in Virginia are different than people's interest in New York. And in larger districts, even you need 50 or 100,000 people to vote for you, you'll have to be kind of an impressive human being to get elected. You'll have to have done something worth caring about before you can run for office. I want to suggest that neither of those work anymore. And they don't work anymore because technology has made the assumptions that Madison and Hamilton made irrelevant. Right? That is to say, news gets around so fast, factions can spread so quickly online, that actually the interests of people in Virginia and New York or Virginia and Ohio can be the same. And you don't need to be impressive or have done a lot anymore to run for Congress. You just need to be outrageous enough to win a primary in a gerrymandered district and be able to get some money from outside sources. And that, to a large extent, explains why the Congress that we have is so deeply problematic today. Right? There's not an easy constitutional fix for that, but it's an area where the Constitution needs one. So, thank you all. I hope this is helpful.